next speaker is Jack Beck, followed by Deborah Hertz, followed by, Evelyn Litwalk.
I want to thank the board for this opportunity to talk to you. My name is Jack Beck. I'm kind of wearing two hats here. I am testifying on behalf of the New York City Bar Association Corrections and Community Reentry Committee, and also the New York City Affairs Committee. I also can't remove my long experience. For the last 33 years, I have been concerned about corrections. I worked at the Prisoners' Rights Project, the Legal Aid Society for 23 years, and now I'm director of the Prison Visiting Project at the Correctional Association, which means I go into all the prisons upstate and have been monitoring conditions in the jails and in prisons for that length of time. We have submitted detailed testimony from the standpoint of the New York City Bar Association that really outlines several of the elements that I think everybody has been consistently critical of the standards. And they go to an overbroad standard. Clearly what your current rules suggest is much broader than even what the department is asking for, and I think much broader than what is actually needed. Second is the problems with no programs inside, which I'm going to spend some more detail on, overbroad restrictions, and no mechanisms to get out. But I want to step back one step. And that is, fundamentally what's wrong here are two basic elements. One is that what is needed to deal with violence is a multifaceted approach. And this is a very limited approach. That multifaceted approach, and actually I would reflect on what the board did, I think it was 8 or 10 months ago when you had a conference where you brought people in from San Francisco's jail. They talked nothing about an enhanced supervision unit. They talked about what is the responsible interaction between staff and the incarcerated population. They talked about a change in culture, not the repressive regime of discipline and isolation. And so what I'm saying is the ESH by itself is a failed paradigm. That paradigm is that you can discipline and isolate yourself out of violence. And it's proved over and over that it doesn't work. So what has to be done? Well, one piece is that if you are going to try to have some control on violence, you have to change that culture. And others will be testifying about that. But there is a small circle in the larger circle of how you make improvements, is that you might have to deal with very troubled individuals, but you have to deal it in an effective way. And that effective way is an intervention that is actually going to work. Isolation and separation, even if you let people out of the cell, does not work. There's myriads of studies that kind of demonstrate the problems with that. What is needed? What is needed is a treatment plan that's individualized for the person. Second, there has to be ways to have that plan actually implemented, and there has to be accountability on how that plan is being done. And when that plan is successful, that person has to be rewarded with the resolution of that so that they can be removed. Second is we have to really diminish solitary confinement. And one thing that has not been mentioned, I don't think so far, is there is a proposal before the legislature right now called the Halt Solitary Confinement Act that has all the basic elements of how you could restrict that. I'd urge you to look at it. It's in our testimony and others that will look into those various components. But they are far too many people are being put in. They're put in too long. There is not actually treatment in dealing with them effectively, and they have to be a way to get out. Very similar to what we're talking about on this unit. But finally, I really want to go to a process question, as your previous witness just talked about. You cannot promulgate broad policy rules without knowing the details. My 33 years of doing this work says nothing more that the only way you know if something's going to work is to get everything clear beforehand. That means you have to see the units that they're saying they're going to be put on. You have to see the program space. You have to see the staffing. Their current proposal has no program staff in it. There's no way you're going to have any meaningful program unless there are dollars and program staff associated with it. You have to see, is there a mechanism to enforce it? This testimony that I found most disturbing was from the leader of the mental health unit, who talked about wanting and intending to do progressive work, yet it never came to fruition. And unfortunately, this is when the board existed, when outside counsel existed. You have to have much greater accountability that involves, I believe, independent, separate monitoring where you're really going to see that they're implementing those rules. This is not an impossible thing to solve. There are other jails, like San Francisco, that have solved these problems. But it needs a comprehensive plan that really addresses violence. And if you're only going to look at solitary and restriction, you're not going to solve the problem. Thank you.
Mr. Becker. Our next speaker is Deborah Hertz, followed by Evelyn Litlock, followed by Scott Haltowitz. Ms. Hertz.
Hi, thank you. I am a volunteer attorney at the Urban Justice Center as well as a member of the Jails Action Coalition. And I just want to say a few brief things because everything really has been said so eloquently and I don't want to repeat what's been stated. But Dr. Cohen, you mentioned that you mentioned training and how that's sort of lacking in all of this. And I think that's important because I recently was at Rikers where I was in the clinic area, and a young man was getting very agitated and started sort of becoming almost aggressive. The immediate response was to have about 5 or 6 corrections officers surround the individual in full riot, not full, but in riot gear with helmets and batons, and so I think there's sort of this disconnect of how we need to de-escalate situations, right? So, yes, there is violence going on. Obviously, we are concerned with safety, but how are we going about this? If we put these punitive measures, which they are punitive, regardless of what has been said. If you isolate somebody for 17 hours a day and you put them in shackles when there's no other way to describe it other than punitive. And I think we need, as we said, we need to move away from this sort of punitive model. It doesn't work, and it's also counterproductive. So what you're saying is, okay, we're going to have programming, right, that maybe helps reduce violent behavior, maybe anger management, maybe CBT, DBT. That's great. But then we're going to isolate people for hours and hours and hours, which could sort of unravel all the work that you've just done. So that doesn't really make sense. As far as what you mentioned about the mental health check-in, as far as being in solitary or punitive segregation, yes, in theory, someone is supposed to come around daily, I believe twice daily, or at least once, check in on how are you doing mental health-wise. But what actually happens, which has been reported to me by many people, is that somebody does come by and whispers through the slot, mental health. Now, if you don't hear it, if you are not, aware enough to and hearing that mental health whisper, you're out of luck because the person has already moved on. So, yes, you may say, well, but all of these services, they're going to have a law library, right? Law library is going to come around, so that's okay. But in reality, what's happening is maybe somebody comes by and says, law library. That is not an effective way for somebody to be able to prepare for his own defense. And just in closing, I want to say that, the fact that we're considering reducing the minimum standards at Rikers, they're minimum standards. They are the bare bone standards. I mean, it's amazing. Like, we didn't think it could get any lower. And here we are in 2015, New York City, right? We want to be an example for other cities, and we're thinking about reducing the minimum standards. And I just like to say, again, that is uncomfortable. Thank you.
Thank you, Ms. Hertz. Our next speaker is Evelyn Litlock, followed by Scott Haltowitz, followed by Reverend Laura Marco.
Thanks for the opportunity to speak.
Thank you.
My name is Evie Litlock. I was released from federal prison this past August, and prior to that I spent 42 days, 6 weeks in segregated housing. So I'm speaking from that perspective. I had prepared remarks, but after listening to the commissioner and other people speak, I'm way too emotional to read my remarks and hope that I'll be able to say what I'm trying to say. I am also a member of JAC and write a blog for my own company called Ex-Offender Nation. The 42 days that I spent in segregated housing, solitary confinement, caused tremendous amount of medical and psychological problems to a point where today I still feel it and know it and have it And by the way, at 63, I believe that putting a senior into solitary confinement puts them on the endangered species list. And I'm not kidding about that. You are challenging their physical ability. You are being asked to institutionalize a jail within a jail. And I don't believe you have the right to do that. I was convicted of a crime. I lost my liberty. I was put in prison. To have a group of people be allowed to operate a jail within a jail is such a violation. I'm speechless. You're also being asked to have it be a 250-bed facility. Mind you, there will always be 250 people, 250 scalpel-yielding people intent on hurting someone in a law library, because that's the image you're being asked to believe. There won't be 249. There won't be 149. It will be filled because you're creating a layer of an institution that will be permanent, and be prepared to be accountable for that, because that's what you will be doing by putting this unit in there. If you believe that the level of violence of those 250 people are the scalpel-yielding things, the fear-induced that you've heard this morning, then you also believe that Saddam Hussein had weapons of mass destruction. It is a lie. I am the face of someone who was a security risk. I am the face of the violence that you're being asked to believe is necessary to create this unit. What did I do? A woman, an inmate, went to a medical officer in serious pain, and she said, I need to be treated. Instead of medically testing her, the officer said to her, you're fat, you need to drink water, and walk on the track. Her gallbladder burst, and she died 2 weeks later. I wrote a blog and sent it out through an email. That was considered a security risk. My email was considered a security risk, a violation of policy, and I was told point blank, I put the officer's life at risk by writing the facts. Now, unless everything is defined so that there can be no question on every word of this proposal, unless everything is defined about what programming is being done, you have my word that whatever is in the rules is not followed. What I live through, is no medical care, even though I asked for it every day. No medical care. I suffered. I don't want to get into that part of it, but suffice it to say that whatever is in the rules and regulations is not followed now. So for something like this, where you're asked to believe, don't worry, amen, we got you, we're going to do programming. Amen, we're going to do this. It's coming. It's not coming. It's never coming. It'll never be there. So before you put into place more torture, I'll ask you to consider another thing. And I use this as an example when I speak. It's not only that you're thrown into a locked, small, horrific space where you share a toilet with someone, but even to get a roll of toilet paper is something you have to beg for. And that's not going to be in the rule book. The things that you need to survive literally is not going to be in that rule book. And it's humiliating to beg for a roll of toilet paper. And what I will tell you is you can put $100 million into training of officers, but if you have not measured for character, for even the ability for them to relate to us, then all the training in the world will not matter. They have to be of a certain nature, of a certain temperament to deal with us. Thank you for your time.
Afterwards, followed by Reverend Laura Margot Downey, followed by Gabrielle Horowitz.
Thank you. Thank you for the opportunity to testify. My name is Scott Paltrowitz. I work at the Correctional Association of New York, and I'm also part of a campaign for alternatives to isolated confinement. There are moments in history when public servants have an opportunity to stand up and end gross injustices that are taking place. Right now is one of those opportunities for the Board of Correction and the Department of Corrections. The levels of brutality that have been documented over and over again at Rikers Island, and the widespread and pervasive use of solitary confinement that is known to be torture, are horrible practices that need to end. And as you can see by today, who is here, how many people are testifying, over 100 people coming to testify, the moment is ripe for radical reform to take place, for fundamental reform to take place. The public is behind progressive reform. The media is behind progressive reform. Policymakers are behind progressive reform, and it's time for that reform to happen. Unfortunately, reducing the rights of incarcerated persons and adopting this ESH unit is not the reform that's needed. When people can be held indefinitely under broad criteria and secret evidence in units where there are no guaranteed programs and harshly punitive conditions with respect to services, that is not the kind of reform that we need. What we need are two major things. One is the end of the torture of solitary confinement. The UN Special Rapporteur on Torture has said that no person should spend more than 15 days in solitary confinement. And that's not 15 days for one rule infraction. That's spending time of 15 days. Because as we know, it hasn't been mentioned yet today, people often receive additional disciplinary infractions while they are in solitary confinement. So even if there's a restriction on 15 days for one rule infraction or 30 days on one rule infraction, that can very quickly become 60 days, 90 days, a year, 2 years. As was mentioned by Jack Beck, the Halt Solitary Confinement Act is a model for how we can end this torture of solitary confinement, but also create more humane and effective alternatives. And I ask the board members to look carefully at that proposed legislation that's before the New York State Legislature, as well as the Jails Action Coalition's minimum standards for how we can end solitary beyond 15 days and create more humane and effective alternatives. The second thing that needs to be done is to fundamentally address violence in a comprehensive manner. And that must start with ending the culture of brutality and staff violence. The comprehensive approach to violence, in our testimony we outline a number of different measures. I'm just going to focus on two things for right now. The first is that there must be heightened restrictions that could be in minimum standards by the board about when use of force can be used and what are the consequences when use of force is excessively used or improperly used. The second deals with violence both by incarcerated persons and by staff. And that is, I think, the bulk of what so many people are saying here today, that the response has to be actually additional support programs, therapy, positive interventions that empower incarcerated persons to help address their issues and be better suited. I just want to read real quickly. I know that Drs. Lee and Gilligan will be testifying today, but I want to just read one excerpt from one of their reports. Quote, "If we want to facilitate the ability of violent people to regain their humanity or to gain it for the first time, so that after their return to the community they will behave constructively rather than destructively, it is essential that the setting in which they are temporarily separated from the community, meaning prisons or jails, be as dignified, humane, and home-like as possible, and that it be a kind of microcosmic example of the kind of health-promoting and nonviolent community that we would hope they could help create and maintain after they return to the community." That's the kind of unit we need to create, not an ESH unit, but an environment that's as home-like and supportive as possible. So I urge the board to rise to this challenge, to take on this moment, and to protect the rights of incarcerated persons, make our jails safer and more humane, and help the people who are incarcerated thrive and be better suited and prepared to return home. Thank you.
Downton, followed by Gabrielle Horowitz Briscoe and Eddie Litlock.
Thank you. My name is Reverend Laura Markle Downton, and I am grateful to testify today on behalf of the National Religious Campaign Against Torture. We are a coalition of more than 300 religious organizations that are committed to ending torture and U.S. policy, practice, and culture. Since our formation in January of 2006, representatives from the Catholic, Protestant, Orthodox, Christian, Evangelical Christian, Buddhist, Hindu, Quaker, Unitarian, Jewish, Muslim, and Sikh communities have joined in NEARCAT's efforts. Our member organizations include denominations and faith groups, national religious organizations, regional religious organizations, and congregations. Whether we refer to it as solitary confinement, punitive segregation, the box, the bing, being denied access to meaningful human contact in U.S. prisons, jails, and detention centers, as we have heard today, rises to the level of torture under international human rights standards and violates basic religious values of community, restorative justice, which calls us to address the root causes of harm and healing, and the sacredness of human potential. It is immoral, and it serves no rehabilitative purpose. As people of faith, we are deeply disturbed that the Board of Correction has abandoned its plans to issue rulemaking to reduce the use of solitary confinement in New York City. We are gravely concerned about the New York City Department of Corrections' request for approval of the ESH, a highly restrictive housing unit that is punitive and, as we've heard today, is not therapeutic. This is a move in the wrong direction. The faith-based members that belong to NEARCAT are united in opposing treatment that violates our values as people of faith. We join with colleagues across New York and nationwide in our work together to bring an end to the torture of long-term solitary confinement. Recognizing its consequences are particularly devastating to young people and individuals who enter prison and jail with mental illness, but as we've discussed today, recognizing that no one should be subject to long-term solitary confinement because it's a practice that itself causes mental illness, literally changing the brain chemistry of those who are subjected to it. We are proud to be a member of the Campaign for Alternatives to Isolated Confinement and are strong supporters of the Halt Solitary Confinement bill that you've heard spoken about today. And I, too, would urge you to consider the approach and content within that legislation, highlighting the level of concern from the interfaith community about the use of isolated confinement and the culture of violence within the New York City Department of Corrections. In August of this year, NEARCAT and TRUA, the Rabbinic Call for Human Rights, co-sponsored an interfaith delegation in which over 30 clergy and faith leaders went to visit the New York City Rikers Island jail complex. We visited solitary confinement units for men and women at Rikers and also met with then recently appointed Commissioner Pont to discuss the urgent need for treatment interventions, for therapeutic alternatives, and for concrete proposals that will bring an end to the use of isolation at the jail complex. I want to also note that at the December 11th meeting that just took place, the New York State Council of Churches adopted a statement against the practice of solitary confinement as it's currently being utilized in New York State and here in the New York City system. Because, quote, they profess that solitary confinement is immoral, inhumane, and again constitutes torture under international human rights standards. With the recent release of the Senate Intelligence Committee's report on CIA torture, the nation's attention and conscience have been riveted by the immorality of torture of those held in prisons, secret or otherwise. At the same time, a culture of violence and the use of torture persists in our prisons, in our jails, right here at home, as we've been hearing about today. The lack of a strong proposal to advance alternative practices to curb the use of solitary confinement is something that we just cannot abide. It is time to acknowledge that torture by any other name is still torture and that it's occurring on our watch. As we respond with horror to the details of the CIA torture report, We must acknowledge the torture that is persistent right here in our backyard. Allow me to close with this.
Very, very briefly.
We are, as human beings, called to and enabled to create community, create possibility. And in this fundamental denial of that space to grow and that space to become, that space for an alternative reality to come to be, this is a fundamental moral problem.
Thank you.
And we ask for your leadership.
Thank you. Our next speaker is Gabrielle Horowitz-Prisco, followed by Eddie Litlock, followed by J.M. Kirby.
Hello, my name is Gabrielle Horowitz-Prisco. I direct the Juvenile Justice Project at the Correctional Association of New York. We share with you a deep concern about the conditions of young people on Rikers Island. I will focus today on young people. My colleagues have already addressed our concerns also about adults. Although we're relieved to learn that solitary confinement for 16 and 17-year-olds has ended, and we support the exclusion of 16 and 17-year-olds from the ESHU, we are profoundly alarmed, at the conditions faced by young people between the ages of 16 and 25 on Rikers, including the continued use of solitary confinement for 18 to 25-year-olds and for all people, the proposed creation of the ESHU, and claims made this week by the U.S. Attorney in court that recent reforms are not reaching 18-year-olds and that more has to be done, including a lawsuit by the federal government against the city. When I was 11, I was in London with my parents, and we went to the Medieval Torture Museum. And I remember vividly saying to my parents, how did people do this? People who are accused of crimes. How did people do this to each other? One day, an 11-year-old girl is going to be on the island that we now call Rikers. Maybe it'll be a park by then. And she'll be in a museum, and she's going to turn to her mother and say, how did they let that happen? And I remind you that no one, even people convicted of crimes, deserves to be tortured. But I've also been astounded in this room that it's barely been discussed, if at all, that the people on Rikers are merely accused. And again, no one, not even those convicted, deserve those conditions. And I also ask you, what if your child or someone you most loved, an adult or a young person, an 18-year-old or a 20-year-old or a 60-year-old, was accused of a crime and was facing this city's prosecution? What would you want for them? And are you comfortable with the rules before you? Do they preserve what you would want for your own child, for the person you love most, for yourself? As you've heard before, we need to do for each other what we would want done for us, and we need to do what we would want done for our own child. That is the standard. What is before you is not acceptable for anyone's child, grown or young. I want to focus on 6 brief recommendations. The first is that you should end the use of all forms of isolation, regardless of their name, regardless of their acronym, and regardless of the age of the people impacted. You heard earlier about an op-ed penned by the head of the Colorado Department of Correction, Rick Ramish, and what's profound is that he describes how in less than 20 hours his mental health was impacted by being in solitary. The man literally had the keys to the jail. It was as if Commissioner Pont locked himself in solitary. He was the head of it, and he talked about his own mental destabilization, what he experienced within less than 20 hours. Make no mistake, shorter-term isolation is still isolation. The second recommendation is that you should immediately evaluate the implementation of any reforms that are proposed to be used as alternatives. We're extremely concerned about we've heard a little bit about the Transitional Repair Unit, the TRU, in which it's my understanding, which is not verified, but that young people may be held for up to 20 hours a day, which is even more than in the ESHU. Why are we holding young people for 20 hours a day in the TRU, and that's called repair? What is reparative about that? When all evidence, and you've heard countless evidence today, shows that that kind of isolation devastates young people's bodies, health, spirits, and minds in irreparable ways. The third is that you, the Board of Correction, should immediately issue proposed rules related to the needs of young people on Rikers. We were so heartened when the coalition that I helped coordinate met with the Adolescent Committee. We were moved by your work. A year you spent doing that work. Where are those rules? We need them. We need you. We need your recommendations. Where have they gone? The fourth is that all children who are detained and incarcerated need to be removed from Rikers Island. It is no place for children. Immediately removed. The Child Welfare Agency of this city would remove a child from their parents if their parent were doing anything close to what was on Rikers Island. I used to be an attorney for child abuse and neglect cases. If kids were removed from their parents for far less than what is happening on Rikers Island. And yet this city is not removing the children using its emergency removal power under the child welfare statute, as it should. The fifth recommendation is that the Department of Correction should move to quickly effectuate separate housing for 18 to 21-year-olds on Rikers. The commissioner applied to you all for a variance to do so, and in the letter that he submitted, he gave fantastic reasons why this should be done. Well, again, what has happened to that variance? It was August 8th, 2014. We would really like to see both the board and the department move on that. And finally, I'm aware, briefly, I promise, that we should look at alternatives to detention and incarceration of children and all people in general. Last, of course. You're welcome so much.
Eddie Litlock, Jay and Kirby, and Ben Power. Thank you.
Thank you.
Good afternoon, everybody. I'm here to testify on Eddie Litlock. My name is Dakeem Roberts. I am the founder of The Negation, which is an organization that ultimately seeks to repeal the 13th Amendment to the Constitution. The Negation is also a member of JAC, CAKE, the Rikers Action Committee, and the Stop Mass Incarceration Movement. I would like you to look at a couple of terms. Enhanced interrogation technique. Enhanced security supervision housing unit. Both of these terms bring to mind one thing: torture. Torture has been condemned by not only your own federal government in the Senate report, but internationally as well, before the UN Convention Against Torture. In light of these condemnations, the people demand you not go forward with the department's plan to introduce torture chambers in New York City. No, I do not refer to medieval torture chambers, employing the rack and screw, waterboarding, the death of 1,000 cuts. No, this is 21st century torture, and it is far more sinister. These techniques deploy sensory deprivation, isolation, and psychological torture. The so-called ESHU institutionalizes and systematizes penalization. Do not be misled. By lowering the minimum standards for the treatment of prisoners, you supply Commissioner Pont with the tools to initiate his program of torture, alienation, and psychological abuse, which he clearly appears to be commissioned to disseminate throughout the United States. We therefore petition to the agency's rule-making authority in the creation of a community review board predicated on the theses of the 7 hoods. The thesis of the 7 hoods holds that 85% of all New York State prisoners come from 7 distinct neighborhoods in New York City. The Community Review Board shall act as a counterbalance to the Department of Correctional Services. Sadly, I have a more personal stake in opposing the ESHU. I am a wrongfully convicted child prisoner, 53 years old. I don't look a child, but I'm a prisoner to this day, on parole for life. 16 years. My imprisonment from the time I was 16 years old to the time I was 40, I was held in state custody throughout the state of New York. As a child prisoner, I fought for life and limb. The center of the universe was where I stood. I became fearless. I became a child soldier. I'm the person you're talking about. I had to become fearless. I had to fight. I had to defend myself against cell extractions. And why? Because they wanted to take my books. They weren't taking my books. I trained under John Smith. Big K.O. Smitty! I became a master cell fighter. And I repelled cell extractions until they couldn't get me. Couldn't come and take my books. That's right. I did that. And it wasn't all the military arts. It was deception. I trained under masters, and they had to drag them out my cell. And they attempted to emasculate me, 15 deep, Abner Louima style. But I fought. You want to see torture? Somebody came up here and gave a bunch of pictures. Commissioner Ponk granted impunity to the man who committed this act of torture. This was in Maine prison where this man was touted as a reformist. This is a per se violation of international law. Impunity to a torturer. What, your man Ponk? He was known as the Butcher of Walpole by the prisoner population in Massachusetts. He ran a unit, a special unit, that engaged in torture. Senator Backman, he distributed to Amnesty International a report. On one side of the report, I pasted it. The other side of the report, this is your ESHU. They are mirror reflections of the same shit.
Thank you, sir.
I have one last thing to say.
Our next speaker is Jan Kirby.
On the day I'm returned to the island and disappeared into one of their ESHUs, I shall declare Occupy Rikers. And the people shall gather in such numbers that the rumble of their feet shall make the earth tremble.
The next speaker is J.M. Kirby, Beth Powers, and Dr. Gandy Lee.
Good morning. My name is J.M. Kirby. I'm with the Youth Justice Project of the International Women's Human Rights Law Clinic at CUNY School of Law. The Youth Justice Project works to remind government officials of their obligations to respect the human rights of young people in relation to the justice system. We are resubmitting a report which is attached to this testimony that we recently shared with the New York City Board of Correction about international human rights standards regarding youth in detention, as well as standards on mental health and solitary confinement. Our testimony today briefly reiterates some of these standards and also highlights standards related to due process and other rights and discipline. We believe the ongoing use of solitary confinement, the proposed new punitive ESHUs, and the new transitional repair solitary units for youth contravene efforts to bring the city into compliance with international human rights standards. While our focus today is primarily on youth, we support the calls to reject solitary confinement and the ESHUs and to expand human rights for all people in the city jails. It is positive that the Commissioner and Mayors have voiced recognition of the dire need for change in the jails, but we believe the proposed BOC rule is inadequate and will actually decrease adherence to human rights standards. In general, these standards call for governments to diminish the use of detention and increase services for youth. And where youth detention is unavoidable, governments should create conditions of detention that help youth flourish by serving their unique developmental needs and respecting their inherent dignity as human beings. While sentencing policy is outside of your purview, it's relevant to note that New York's policy of treating some youth as adults in the administration of justice contravenes international human rights standards. the UN Human Rights Committee has specifically recommended that states like New York that automatically exclude 16 and 17-year-olds from juvenile court jurisdiction change their laws. Additionally, juvenile justice policies and programs should apply at minimum up to the age 18, and international human rights monitors encourage governments to apply them to youth aged 18 up to at least 21. To begin to meet human rights standards, the BOC should utilize its rulemaking powers to ensure that conditions of youth confinement reflect appropriate juvenile detention practices. I'm going to, in the interest of time, skip some of the testimony that I've emailed to you that addresses separation of youth from adults, physical space and visiting, and education and programming, except to just emphasize that I want to recommend the treatment model advocated by Cardozo Law School in its recent report to the New York Board of Corrections on alternative treatment for youth at Rikers is very much in line with international human rights standards regarding programming for detained youth. Just moving on to discipline and solitary, the UN Human Rights Committee and the UN Committee Against Torture have both called for review by an independent body in disciplinary decisions of all people deprived of liberty. And there are other specific standards related to due process for youth in disciplinary decisions. International human rights law is absolutely clear that youth under 18 must not be subject to solitary confinement, and UN human rights bodies have specifically criticized the United States for subjecting juveniles to solitary. Given that international human rights experts encourage expansion of juvenile justice practices to youth older than 18, this would suggest that the U.S. should take steps to prohibit solitary for these other young people as well. The provision of the proposed BOC rule that would exclude 16 and 17-year-olds from solitary is a positive step. However, it is our understanding that the new transitional repair units for youth entail 20 hours of daily lockdown. There's no written directive for implementation that would describe the standards for placement and or removal from them, for how long they will be held in them, or for the services that youth in them might receive. Also, language similar to the most dangerous category being used to justify the ESHUs is apparently also being used for the TRUs, which may further belie public promises that youth will not be subjected to either solitary or ESH-style units. International human rights standards call for the treatment of detained people to emphasize not their exclusion from the community, but their continuing time in it, and to minimize the differences between prison life and life at liberty. As part of this approach, human rights standards call for detained people of any security category to have access to an adequately stocked library that they're encouraged to make full use of. Regarding discipline, due process, and respect for human rights, these are key principles under international human rights standards. And regarding restrictive security measures, the European Court of Human Rights has found that routine strip searches before and after each visit as part of a regime of strict control amounts to inhuman or degrading treatment. And so I encourage you to visit all of these standards.
Our next speaker is Beth Powers, followed by Dr. Bandy Lee, followed by Steve Simon.
Good afternoon. How are you doing? All right. My name is Beth Powers. I'm the Senior Juvenile Justice Policy Associate for the Children's Defense Fund, New York. My comments today are going to focus on the potential impact on adolescents of the proposed rule. In the past year, CDF New York, along with other advocates for system-involved youth, have met with the Adolescent Committee of the Board of Correction to discuss the harms of isolated confinement and age-appropriate alternative interventions for confined youth. We're grateful for the Adolescent Committee's close attention to these issues and sincerely hope that any rule promulgated at this time limits the use of isolated confinement of any sort for adolescents and young adults aged 16 to 24. To be completely clear, CDF New York strongly supports the removal of all 16 and 17-year-olds from adult corrections. We believe that these young people are better served in the juvenile system. And to the extent this cannot be done immediately, we urge the city to initiate a planning process to expedite the removal of this age group from adult jails, while also ensuring they are not placed in isolated confinement during their time in adult corrections. CDF New York strongly supports the elimination of the use of punitive segregation for 16 and 17-year-old adolescents. We applaud the Department of Correction for taking this monumental step in the treatment of 16 and 17-year-olds, and the board for acknowledging that punitive segregation is a serious and unacceptable threat to the physical and mental health of inmates who are adolescents. We additionally support the exclusion of 16 and 17-year-olds for consideration in the development of the ESHU. We understand that 16 and 17-year-olds have begun to be placed in 2 new units as alternatives to punitive segregation. While we're greatly encouraged by the prospect of the new alternatives to punitive segregation, we strongly urge the board to monitor the new units to ensure they are implemented as intended, with focus on programming and as an alternative to segregation. As we heard earlier and has been brought to our attention, adolescents on the Adolescent Transitional Repair Unit may be confined to their cells 20 hours a day. We urge the board to investigate this concern and ensure that youth are not subject to any form of prolonged segregation. The isolation of adolescents under any and all names should be ended in New York City jails, and age-appropriate positive behavioral responses put in place to ensure safety. We've heard plenty about the excessive harms of isolation. I'm not going to go into that. There's plenty in my testimony. I want to repeat what I heard about the Department of Justice report and urge immediate action in regard to 18-year-olds that has been neglected, and also reiterate what has been said about the Department of Correction looking into the special needs of 18 to 21-year-olds. At the time, they cited age-appropriate services and entitlement to educational services as a benefit to housing these young people together. We're enthusiastic about that, but also encourage this age group to be excluded from punitive segregation or any form of isolation. While our recommendation is to ban the use of restrictive housing for adolescents and young people, at a minimum, we strongly urge limitations on the use of such housing for this population. All young people should have access to full educational services, should not be limited to self-study. Additionally, all young people should have access to robust age-appropriate services. Family engagement is an important element of appropriate rehabilitative services for adolescents. We're particularly concerned with the limitations in the ESHU would place on contact visits and the impact of this policy on adolescents and young adults. To the extent that young people continue to be placed in isolation, at a minimum, they should be allowed time out of cell to attend school, mental health services, family visits, and other programming. Additionally, limitations should be placed on the number of consecutive days in which people can be subject to any form of isolated confinement. In addition to our concerns with the conditions older adolescents and young adults will be subject to, we're concerned with the process by which individuals will be placed in the unit. The broad language currently proposed would allow someone to be placed in a highly restrictive setting for being a safety threat. We ask for the use of concrete indicators that are not reliant on subjective impression of DOC staff when making decisions that will greatly impact the treatment of young people. The board must ensure that the procedures in place to notify an inmate of placement on the ESHU, including the option of a hearing, are clearly and plainly explained to adolescents and young adults, and urge the allowance of representation from an attorney or non-DOC employed advocate. Given the vulnerability of young people, particularly those with mental health concerns, the DOC must ensure that these young people are adequately and fairly represented when there are such steep consequences. It's our hope that the DOC will develop and the board will enforce age-appropriate interventions for the adolescent and young adult population in New York City jails that will allow for jail safety to be maintained and positive programming to be accessed by all young people without the need to expose youth to practices that are known to be detrimental to their well-being. Thank you.
The next speaker is Dr. Bandy Lee, followed by Steve Seidman, and then Deborah Hertz. Dr. Lee.
Good afternoon. My name is Bandy Lee. I am Bandy Lee, a correctional and forensic psychiatrist at Yale University, specialist in the study of violent behavior, and one-time staff psychiatrist at Rikers Island, as well as around a dozen of the more notorious prisons around the country. I'm testifying on behalf of myself and Dr. James Gilligan, my colleague from New York University, in response to the New York City Board of Corrections' proposed rule to establish a new form of preventive detention, or the enhanced supervision housing. The proposal calls for placing inmates into prolonged, slightly modified solitary confinement based on forecasts of what an inmate's future behavior will be, rather than as a means of interrupting an immediate, actual, and specific act of violence. This is in contrast to containment for a strictly limited, short-term cooling-off period, so as to allow the inmate as much time as he needs to discontinue his violent behavior, to get his violent impulses under control, and to return to his current residential unit in a peaceful manner. The latter is employed strategically in clinical settings for therapeutic reasons, usually lasts minutes to hours, rarely more than 24 hours, and is an effective means of behavioral control. The proposed rule, as described in the department's directive, however, is being aimed at decreasing the frequency of violent acts by inmates by means of locking them up still for most of the day, during which time they are deprived of almost all contact with other human beings, which is why it is solitary confinement. Programs are the only means we know of for reducing violence in the correctional system, which in the absence of programs generally increases individual violent behavior while in jail and when out in the community, and drastically increases violence if solitary confinement has been used. For mentally ill individuals, treatment can also be effective. Solitary confinement substantially reduces the chances for access to both of these services. The main mistake in this proposed new form of solitary confinement, therefore, is that it attempts to reduce violence by moving in the exact opposite direction of what our understanding is of human behavior and of the effects of lack of human contact on brain and behavioral functioning. Decreased interaction with other people, rather than moving in the direction of decreasing violence, actually increases violent behavior and the need for more intensive measures. This is because solitary confinement, in which people are deprived of human contact, interactions, and relationships, actually increases the frequency and severity of violence toward others and toward the self. This has been demonstrated in multiple studies, including a recent one specifically done at Rikers Island. In the treatment of violent individuals in the correctional system, it's about time we recognize that the only practices that have been shown to reduce violence in prisons and jails are the exact opposite, namely maximal interactions and chances of socialization. Neurological evidence shows that social contact may be even more important to survival than food. Just as we can expect healthy functioning only in the presence of adequate nutrition, we cannot expect behavioral improvement in the absence of habilitation and socialization, often habilitation for the first time for these individuals. So what alternatives are there to the use of force and solitary confinement as means of preventing or at least reducing the frequency and severity of violence? My colleague Dr. Gilligan and I, for 10 years, have worked on a violence prevention program through the jails of the city and county of San Francisco. Since the late 1990s, we were involved in intensive programming of education and therapy. Inmates, all of whom were in jail because of a violent crime, were in well-designed, constructive group activities, 12 hours a day, 6 days a week. The result was that the percentage of inmates who engaged in violence of any sort, including even non-lethal assaults and suicide attempts, dropped from roughly 60% per year to literally zero for up to a year at a time when we did the studies. Solitary confinement proved to be completely unnecessary. In fact, the program was done in open dormitories, not even cell blocks, of all violent men, which quickly became the safest dormitories in the entire jail system. So this can be done. And even more importantly, the frequency of committing a new violent crime after leaving the jails was 83% lower among the inmates who were in this program compared to an otherwise identical control group in the conventional jail. And since then, many similar programs around the country and the world have replicated similar programs. So, yes.
Thank you very much. Indeed. Next speaker is Steve Seidman, followed by Deborah Hertz, followed by Alberto Rios.
Good afternoon to the stalwarts. My name is Steve Seidman. I teach at CUNY Law School. I also serve on the board of directors of Prisoners Legal Services. Look, there are so many issues to discuss. You've heard them all. So many of them are raw, personal, emotional. I just want to begin by seconding so many of the comments of the advocates, from Jack from the Legal Aid Society, the Correctional Association. But what I want to talk to you about for a couple of minutes is about due process. Just one specific, very legal issue. The 5th and 14th Amendments, which prohibit government from taking a person's life, liberty, or property without due process of law. And really what it boils down to is fundamental fairness and decency. And we should be very clear, this is a moment in time not just about solitary confinement, but due process is very much in the national discourse these days. We hear it come up in the context of the homicides of Michael Brown and Eric Garner, and the ways people are recognizing that due process means different things depending on whose due process it is. Due process is also at the center of recent historic decisions in other contexts, right here in New York City, that I believe the board should take heed of. For example, providing lawyers for poor people in immigration proceedings. Let's be clear, there's no constitutional right to have an attorney, but there was a felt need, there was a crisis, and people responded to it. Similarly, there's now a movement afoot to provide counsel for poor people in housing court. Again, is there a constitutional right to counsel? No. Why are people turning their attention there? Because there's a crisis, there's a need. So too with Rikers Island, whether we refer to solitary confinement, punitive segregation, extreme isolation, enhanced supervision, there is a need, there's a crisis. My colleagues and I, Donnelly and Nicole Smith at CUNY Law School several months ago, had proposed a pilot project whereby law students, and I know this was alluded to earlier, would provide representation for people at Rikers Island facing disciplinary charges. And it was our hope that eventually, when people saw the benefits of such a program, that it would expand into an organization that would provide representation on a regular basis. And we did some homework. We looked backwards to see, and all over the country, frankly, to see what kind of representation is provided to prisoners. And in fact, while some states do provide representation, it's usually after the fact, after there has been a finding and someone is appealing an initial determination. And we believe that if people step back and think about it, and in particular the department gets over a knee-jerk reaction that we don't want lawyers involved, they would see that this benefits not just the incarcerated, but the Department of Correction and all concerned about fairness and due process. Start with a basic fact I think we would all agree. One of the primary sources of inmate frustration is the lack of meaningful ways to voice concerns or complaints, or, germane to the hearing this morning, to adequately and knowledgeably defend against disciplinary charges. We know in Wolf versus McDonald, the Supreme Court set the floor regarding due process, but the board has an opportunity now to provide greater due process, to do something innovative, to do something that is real reform. I'll give you two specific reasons why. Much has been written about the concept of procedural justice, this general notion that if, for example, a criminal defendant feels he was treated fairly during the adjudication of his case, he is less likely to harbor resentment and, according to some researchers, even less likely to reoffend. It doesn't take much by way of imagination to think about what goes on in someone's mind in punitive segregation, all the while festering, thinking about their hearing and what they believe to be a lack of an opportunity to be heard. I should also point out that the presence of advocates would obviously serve to elevate the substantive due process, the fairness of these hearings. As it stands, presently, the accused may or may not raise appropriate objections, cite to the correct standards, or raise valid and timely defenses. I mean, consider that 95% of disciplinary charges are sustained. That is hardly surprising given the fact that there is no legal representation, no right to cross-examine, and the judges are Department of Corrections employees. I mean, 95% so far surpasses the conviction rates in the criminal court that really the only conclusion that any objective person can make with that number is that the hearings pay lip service to due process, that the result, as everyone knows, is a foregone conclusion. And by allowing for the role of counsel, whether for punitive segregation or for the enhanced supervision housing units, the board goes a long way to correcting, I think, that clear problem. If I could very briefly, I think you've heard most of these. I'll just point them out again just to reiterate. What are some of the due process problems with enhanced supervision housing units? Again, there's no right to counsel. Again, no right to cross-examine witnesses. Again, the judge is not an independent arbiter. But one thing just to highlight, the lack of due process, when you consider the classifications or categories that subject someone to ESH, to say they are vastly overbroad, all you can say is it's an incredible understatement. Whether the individual is a participant in a gang or, quote, substantially similar group, one can only wonder what exactly that might be. So again, to say it's overbroad is an understatement. Whether called punitive segregation or enhanced supervision housing, it is to the person affected a deprivation of liberty. And the Board of Corrections should mandate that will not occur unless the accused was provided with counsel and a semblance of real, true due process.
Thank you, Mr. Zahn.
Thank you.
Next, we'll hear from Stephen Rizzi.
Hi, good afternoon, members of the board. My name is Stephen Rizzi. I was detained in custody. I was never convicted of what I was detained for. The charges were dismissed, but I was in the custody of the New York City Department of Correction on Rikers Island from November 2008 until April 2012. I'm here to testify because I think that the restrictions and the lock-ins are very similar to punitive segregation. This was my first and only time in jail. While I was in Rikers, I spent some time in a mental observation house in AMKC, and the majority of the time I was in the Bing at GRVC in Maui. I spent about 2 to 2.5 years in the Bing. During the later part of my time, I was also placed in enhanced restraint status. You're familiar with enhanced restraint? Yeah. When I was in jail, I finally received some mental health treatment. When I was placed in the mental observation house, I used to go to group therapy and anger management and got regular medication, and it was very helpful. But after spending much time in the Bing, I felt like my mental health symptoms got worse. I felt more aggressive, more angry, and sometimes suicidal, which wasn't like me. It took me a very long time to adjust. And I received mental health treatment to this day for my time in Rikers Island, because it was very traumatic. While I was in the Bing, I was housed at the ITU. You're familiar with the ITU? That was very helpful for me, very helpful. I got to see a clinician and did lock out and attend group therapy. On most days I was allowed out the cell for a few hours, including recreation. But I found being locked in my cell for such a long time, like the inmates have to lock in for the ESH. It's very traumatic. Another time I was sent to the Maui Bing for the first 3 days and placed on suicide watch, even though I was not suicidal. That was the protocol at the time for being admitted in Maui. And I was not at the ITU at the time, and it was even worse. The reason for me being on suicide watch is because the medical records takes 3 days to transfer from my original facility to the Bing. So I wasn't given any medication for a few days because of that, and I suicide watch. So I had to be in the cell for 3 days, wearing only a smock, having no reading materials, sheets, or phone calls, and I felt isolated and disoriented because I was not getting medication and because of the total isolation. When I was in the Maui, there was no congregate religious services, which I believe you're entitled to under correction law, New York State correctional law. And I was barely afforded recreation because the staff never announced it at a specific time, and plus you don't know, you can't keep track of time when you're in the Bing. And there was also limited cells outside, like cages, so they couldn't afford everybody recreation. Even though it looks good on paper, they couldn't afford everybody recreation. And also, most of the time I remain confined to myself for 24 hours a day for weeks at a time, except when I will go see my counselor. The mental health care was superficial. I did not get along with the psychiatrist in Maui Bing, and felt that my mental health treatment wasn't as good because of it. I tried to keep busy with legal research and writing letters to my family. The Bing drove me nuts. I began talking to myself because of isolation, lost time and sense and reality. There was nothing to look forward to because there was no positive incentives for me. I opposed the ESH because the proposed rule is too vague and discretionary to DLC staff, so they could basically put anybody they want that they feel needs to be in ESH to ESH. Also, the long lockdown is almost the same as the Bing, like my time in ITU. The total booth restrictions will hurt family relationships. In jail, nobody ever touches you. Inmates look forward to contact visits so they can see their loved ones and get positive social interactions like hugs and handshakes. It makes people feel normal for a little while when they see their family because they can be themselves. It makes people feel normal for a little while they see their family because they can be themselves and not just inmates at Rikers. Can I say one more thing? I'll be brief.
Yes.
All right. There's no positive incentive for full contact visits after they're taken away, and the behavior is not related to the visit. Most inmates will have most inmates will behave to see their family. Also with the packages, I disagree with the pre-approved vendors list because, for example, when my grandmother used to come visit me, she had no internet. She didn't know how to use the internet, and she's poor. You know, I don't know how the prices are going to be on the vendors list. Also, if DOC is allowed to read all mail, it will also hurt family relationships because there's not going to be, people will be more reluctant to have open communication between them and their family members and the loved ones. And that's it. Thank you for having me time to testify in front of the board.
Thank you.